This
Maureen
conference will now
O'Keefe,
be recorded.
and I'm the Executive Director of the Foundation of the Diocese of Raleigh. One of the things that we are responsible here at for the foundation is estate planning and plan giving. We serve as a resource to parishes, donors, individuals, priests, anyone that needs information about plan giving, leaving an estate gift, or anything just in helping plan and answer questions. So I thank you for joining us today as we share this Catholic estate planning seminar with you. Next slide, please. So the foundation was actually established in 2019 by Bishop Zarama, and we were established specifically for three reasons. One, to be responsible and be stewards of the future of the Diocese of Raleigh. We specifically are tasked with really being I call it the savings account of the diocese versus the checking account of the diocese. So we are a separate 5013C corporation from the diocese. However, we obviously work in partnership with them to support all the diocesan ministries, parishes, and individuals. We provide grants in the form of endowment distributions for all the Catholic ministries of the diocese. We currently have over 150 endowments that support parishes, schools, seminarians, land expansion, the poor, Catholic charities, as well as a number of donor designated endowments that also support specific schools for tuition or seminarians. So we as a diocese are very well positioned for the future, and we want to continue to foster that growth as we enter the 100th year of our diocese. That'll be kicking off at the Eucharistic Congress on October 21st. And so our role today is to really look to the future and help you plan as you're looking at your Catholic estate planning. As you know, our diocese is very large, 54 counties, 32,000 square miles, and my team and I get out and visit you regardless of where you are in those 54 counties. We are responsible for managing the endowments. And so again, we currently have $70 million in endowments that I shared with you that support a number of diocesan ministries as well as parishes and schools. We do report into a board of directors that's made up of volunteers. Here within the diocese, we do have an investment committee that advises us and works on the investment part of our endowment portfolio. So today you're going to hear about what you need to do as you start thinking about your legacy and planning. Ryan's also going to share with you today some documents that we have here at the foundation that we're happy to send to you after the session if you'll just send us an email. And one of them is the Catholic Estate Planning Workbook. And in that workbook, it gives you the opportunity to really just write down and fill in some questions and blanks about some of the things you need as you start to make those preparations. And then we also have a document called the Catholic Medical Directives, which is another document that we can share with you that talks about end of life. What is the Catholic teaching around end of life? And so, again, that's just something we can share with you as well. So joining us today is Ryan Flood, who is our plan giving specialist here at the foundation, and also Andy Blair, who is an estate planning attorney and CPA with the firm of Pointer and Spruill. So he'll be here to answer some questions as well. So thank you for spending time with us today. We want to be here as a resource to you, and I'm going to turn it over to Ryan.
Thank you very much, Maureen. As Maureen mentioned, yeah, I've been here with the diocese in one capacity or another, and now for the foundation for about 12 years. I've worked with many parishioners over the years throughout the diocese. Our parish is, my family and I attend St. Luke's in North Raleigh. And today, some of my kids have fall break, so I'm broadcasting from rainy Holden Beach. So if anybody's down here, I'm down in here in rainy Holden Beach, hoping for the weather to break so we can go to the beach later or tomorrow. Um, I'm just going to talk about some of the ideas for planning, preparation for planning, some of the documents, some of the more popular ways of giving, and then I'm going to turn it over to Andy Blair. Andy's a great attorney there right in Raleigh. Has been on a number of presentations with us, and he's going to cover some of the essential documents that everybody needs in their plan. Next slide, please. So what matters most? So before you go to see an attorney, you want to start to think about these things and pray on these things. What are some of the things that matter most to you in your lifetime? Of course, your family, your friends, your community, your church. So what are some of those ways? How do you want to be remembered? Some people want to be remembered, as Maureen mentioned, with a named family fund or named endowment fund. A number of people have done that, but some people want to be totally anonymous. So we can do either way, or right, or something in the middle. And passing on your values more than your valuables. Today, we live in a society that people have a lot, right? We have a lot of material goods, but sometimes values are lacking. So how do we do our best to pass on our values to the next generation? And again, that's done through our community, through our church. How to pass on the importance of the Catholic faith. These are all things you want to be thinking about. And how do you want to get there? This seminar will hopefully be a good first step or second step on moving in the right direction to putting some of these, your ideas and plans in place. One of the questions I ask when I meet with people, a lot of times, before someone, meets with an attorney or someone like that, we have services at the foundation where we'll just meet first to talk about ideas. I've been doing this planning for over 23 years. So I've handled a lot of different situations. Most people, of course, will need an attorney to do the final documents, but in some cases, to pass on assets, you may not need an attorney. So we'll talk about all these different ideas. But what it comes down to is, what are you trying to accomplish? Some people have sold a capital asset over the year, maybe possibly a vacation home or a rental home, and they've had a large capital gain. How do you want to offset that gain? Well, you can do that with a charitable gift. That charitable gift can also provide income for your life or lives. We'll talk about that. Or some people might need more income. You might have a CD paying a very low rate, and a charitable gift annuity will pay a much higher rate. So are you looking to get an offsetting deduction, or you're looking to increase your income? These are some of the ideas we can talk about. How should you leave assets to children, to grandchildren? What is about something you want to leave to charity? We can talk about that as well. And what might you and your spouse need to live on for the rest of your lives? That's primarily answered by a financial advisor if you have one. But to have, again, these basic questions answered before you get into your planning, this is what we can help you with. One of the items that has been very popular over the years, that we've given out hundreds of these, maybe even in the thousands now, is the Catholic Estate and Personal Planning Workbook. If you would like a copy, please email Alicia and she can get one in the mail to you. A little history of this book. This was put together by a colleague of mine a number of years ago in a situation where his aunt had passed away intestate. Andy may talk about that a little bit later. And that's basically, she had no plan in place at all for her assets. And lucky for them, the judge named my former colleague's mom as the personal representative. Didn't have to, but did, and so that was good. But they had such a headache of going through all the estate and finding the different assets, the different statements, this and that, and it took a very long time. And so out of that difficult process came this workbook. We don't have time to get into this workbook today in this seminar, but it's a 34-page comprehensive workbook that'll help you put all your ideas in one place. Again, another tool to use as you prepare for your estate planning documents. There's also a number of checklists in there, what to do the first month after someone passes, or the first 6 months, or the first year. There's references for grieving resources. So, and it's written from a Catholic perspective. It's not one of these secular workbooks. It's a very well written book from a Catholic perspective. It has all the assets and liability listing and all that in there, but also has a lot of information written from a Catholic perspective. So I encourage you to request this workbook and to have it on hand. Again, it helps to keep you organized, and it also helps for people who are going to step in for you in case you become incapacitated or when the Lord calls you home. They'll have everything right there for you. We do not recommend putting it in a lockbox because that might be difficult to get at, but putting it in some place that's secure, a dresser drawer where only a few people might know where it is, because it does contain some sensitive information. But again, it's very, very helpful for you to have the planning and to have the people that'll step in for you after your passing. Again, some of the benefits of plan giving: it's a way to set up a gift for you can set up income for yourself, and then also have a gift to your favorite ministry or parish at the end of your life. There's ways to set up gifts through wills and trusts. And again, we're here to help you with this. Next slide, please. Again, some more of the breakdown there of different gifts. We'll talk about life income gifts, gifts from an estate, or as Maureen mentioned, charitable funds held at the foundation. Next slide, please. Okay, a few more popular ways that people are giving these days. And number one is the qualified charitable distribution. So if you are over the age of 70 and a half, you are eligible to make a direct distribution from a traditional IRA to a 501c3 charitable organization, which your parish or any ministry in the diocese is, and not have to count that as income in the year that you make the gift. This has become very popular over the last few years. Typically, towards the end of the year, I'll get a phone call and they'll say, Ryan, I'd like to use my required minimum distribution. That's the RMD, which now you don't have to take till you're 73 years old. So most people don't take the qualified charitable distribution at 70 and a half, but you can if you want. But you don't have to take an RMD, required minimum distribution, until you're 73. So I'll get a call and they'll say, I'd like to take care of my offertory giving at my parish for the whole next year of 2024. I would like to use my qualified charitable distribution to do so. So I'll talk to them. We'll get them our letter of instruction on how to make this transfer. They'll give that to their plan provider. The plan provider will cut the check. We'll get the check. It'll come to us, and we'll process it wherever the person wants. Some people want it directly to their parish. Some people want the funds distributed to a parish or one or two of their favorite ministries. We can help with that as well, where you don't have to have multiple checks. You can just send us one, and we can distribute it to where you want it to go. And no extra fees are taken out of that. So whatever you give is what your church or ministry will receive. Another way we've seen people use their qualified charitable distribution is to set up endowments during their lifetime. With the qualified charitable distribution, you can give up to $100,000 a year, and now it's indexed for inflation. So in 2024, it'll be a maximum of $101,000. But anything in between, all the way down, $500 or something, or $250, all the way up to $100,000. So that's one good way, to make a charitable gift. And it's like an above the line deduction. Again, you're not counting that as income. So if you have to take a required minimum distribution and you're seeing your other costs, Medicare Part B and other things keep going up, possibly you might want to consider using your qualified charitable distribution from your IRA as a way to lower your taxable income and set up a charitable gift. I've also worked with people who, over their lifetime, put a lot of money into their IRA, thinking that they would need every dime of it on their retirement, but their stock portfolio has done very well, and so they use income from that. So so now they have almost too much income. So again, another way to use that qualified charitable distribution to make a gift and to keep that income lower. Next slide, please. Yep, I covered this. Next slide, please. and there, yeah. So the beneficiary designation is a great gift to give outright during your lifetime, but also as a way to make an estate gift. You can set this up as a beneficiary designation. Now, the IRA is an IRD asset, which means any of that funds coming out of that IRA, going traditional IRA, not a Roth IRA, a traditional IRA, going to a non-charity, such as a friend or an heir, is going to be taxed to them at their tax rate. But if a percentage goes directly to a charity, like your parish or favorite diocesan ministry, the full amount of the gift goes there. No taxes are taken out of that. So it's beneficial there. We say, they're good assets to give to heirs, and there's good assets to give to charity. This is a good asset to give to charity. You don't have to give the entire amount. You can give 10% or 15% or 50%, whatever. We recommend percentages and not dollar amounts because no one knows how much is going to be left. And then whatever that percentage is goes directly to the charity. And the same thing for heirs, but just remember that the heir is going to pay income tax at their income tax rate on beneficiary designations from an IRA, traditional IRA. Very easy to set up. We have the instructions here. We can send to you. You would need our legal title, tax ID number for the beneficiary designation. Moving on to bequest. The bequest is another way to set up a gift to your favorite ministry or parish. If you're going to update your plans anyway, it doesn't cost anything extra to add a few charities there. Just make sure when you go to see your attorney there that you have the legal title and the tax identification number of the charity. In our case here with the diocese, we'd like to have the gifts come to the foundation, and just as I mentioned before with the qualified charitable distribution, we can then get them out to the different charities and ministries. The reason we say that is some parishes and some ministries aren't equipped to handle this type of distribution on the other end, especially nowadays. Is 23 years of doing this, it's getting a little more difficult. Some of these plans don't like to give up assets so easily. We had a situation out there in New Bern recently where we had to work with Truist Bank, because there used to be BB&T and then it became Truist. We also have a situation where we're working with another investment house. So we have the ability on staff to help on the other side of that with the distribution in a timely manner. So what we say is make the gift to the foundation for the benefit of St. Michael's Catholic Church, or for the benefit of St. Catherine's, things like that. Or for Catholic charities, however you want, but make the benefit of. And what we do is we have a memorandum of understanding. So you can set up the gift for the foundation under the foundation's legal title and tax ID, but the memorandum of understanding is on file with us, saying how you want the percentages broken down. 50% to Catholic charities, 50% to my parish, or 25, 25, 25. And that memorandum of understanding can be changed at any time, and there's no cost to changing that. The challenge I see with a lot of people, they'll set up a will or a trust, and then they'll change their mind about something. Then every time they go back to change that will or trust, there's going to be costs involved. But if you set it up just for the foundation, have the memorandum of understanding on the side, updating the memorandum of understanding if things change, there's no cost in that. So please keep that in mind. That's a bequest. Life insurance, very similar to a beneficiary designation of an IRA. You would just call up the life insurance company and ask for the change of beneficiary form, and they'll send it to you. You complete that, and then that's a way to make a beneficiary gift. Also, if the life insurance you don't need it anymore, it's worked through its lifetime use there, you can give the policy and the paid up value directly to the charity. And you could be eligible for a charitable deduction. So keep that in mind with whole life insurance policies. Appreciated securities. I've seen a number of people when they're having a capital campaign, for instance, at their parish, use appreciated securities. Some of the benefits there is there's no capital gains tax when the appreciated securities are transferred to a charity. Don't cash them out and then give the cash. Just transfer them. And so you want to use low basis stock. And we have the transfer instructions all set here. You would just request the transfer instructions from us, give them to your broker or financial advisor. The gift comes in, and just like with the qualified charitable distribution, we will get 100% of the gift back out to whatever ministry or parish you'd like, and then get you your tax letter, for your year-end taxes. But a lot of benefits there of giving appreciated securities. Just keep in mind, a little bit different than cash when it comes to the taxation. You're able to deduct 30% of your adjusted gross income on gifts of stock versus 60% if it was a gift of cash. But you do have the 5-year carry over period. So, you say, well, what if I can't use the whole deduction up in year 1? That's okay. You have the year that you make the gift plus 5 years to use up that deduction on your taxes if it's a larger gift, say for a capital campaign at your parish. So you won't. Most people will use it up in year 2 or year 3, but you have up to 5 years to use that. You're not going to lose that charitable deduction. U.S. savings bonds. I've heard people, they have some of these in lock boxes or shoe boxes, but they are still around. A lot of them have been transferred to an electronic. They're being held electronically, but some still have the physical bonds. They make a great charitable gift because giving these to heirs, again, they're going to be taxed at their tax rate. But if given to charity, the full amount goes to charity. But it's very important that you don't endorse the back of the bonds. Don't do anything with the bonds. Make sure that you have the specific wording in your will that transfers the bonds, the physical bonds or the electronically held bonds, to the charity, and the charity cashes them in. Therefore, no tax will be paid on those. If you would like that specific wording, please let us know and we will get you that. Charitable gift annuities. These are over 23 years. They're kind of ebb and flow, but they're quite popular now because the good thing about a charitable gift annuity is that it's a fixed rate for life or for lives. And so the rates are paying based on somebody's age, actuarial tables, 6, 7, 8, in some cases 9%. Excuse me. So these are wonderful ways to get income for life and then have a gift at the end for the charity. You can set them up for a single life or for 2 life. I've seen this used where I worked with a gentleman in Hillsborough some years ago where he set up one for him and his wife. And if he were to pass away first, his wife would keep getting the income checks uninterrupted every quarter. So he set up that for that purpose. I've worked with people who have set up what are called deferred gift annuities, which means they didn't need the income right away. And so they deferred it 5 years or 10 years down the road where they might need it, but they get the charitable deduction in the year that they make the gift. So that's something to keep in mind. Not all the income is taxed as ordinary income either. Some of it is return of principal, so it's a good benefit as well there. Most gift annuities are funded with either stock or cash. Appreciated securities, as I mentioned before, can be used to fund a charitable gift annuity, or cash can be used to fund a charitable gift annuity. This is a contract between the foundation and the individual, so it's backed by all the assets of the foundation, and you will get quarterly payments, again, for life. You can have them set up direct deposit into your checking account, which a lot of people do now. And at the end of each year, we'll give you a 990 a 1099 for your taxes, and then you have that for your CPA. But they're very easy to set up. 1 or 2 pages contract. That's it. Once they're in place, again, they're for life. If it's a 2 life, is for one life, and then the other person passes, the other person gets it for their life, and then the remainder goes to whatever ministry you want. And I've seen some people even name multiple ministries or parishes as remainders of their charitable gift annuity. So a lot of people like the gift annuity. One other thing to keep in mind too, just made law this year, is that now you can use your qualified charitable distribution, as I mentioned before, from your IRA to set up a charitable gift annuity. The maximum amount on that is $50,000, or you can do anything below that as well. But that's a once in a lifetime opportunity there that you'll get, but you can do that. Not a ton of benefits there because all the income on the IRA to CGA is taxable. But instead of taking all that income at once, let's say your required minimum distribution is $25,000 or $50,000. Well, you can put that into a gift annuity and spread that taxation out over your lifetime instead of taking it all in one year. So most people, though, however, still use cash or stock to set up gift annuities, but now you have the option just in 2023 and going forward of using your qualified charitable distribution to set up a charitable gift annuity. If you'd like more information on charitable gift annuities or a detailed 15-page illustration on all the benefits and how something will look in your particular situation as far as taxes and things like that, just let us know. You can set up an appointment with myself and go through that, but we would just need your date of birth and the amount you're considering, and then we can run that gift illustration and get that gift illustration out to you, and you could review it with your advisors to see if that might be something that would benefit you. There it is. I got ahead of myself there. Yeah, the IRA charitable rollover again can be used for a gift annuity, just new in 2023. Charitable trust, again, we can do a whole presentation just on charitable trust, a little more complicated, but they're certainly good for some situations, complex assets. I've worked with people who've used land, farm equipment. You can still use cash or stock as well, business interests, real estate. Those assets can be used to fund a charitable trust. Gives you a little more flexibility by using those assets. Again, provides income for life or lives of individuals. You can have multiple, not just one or two, but you could have 3, 4, or 5 income beneficiaries with a charitable trust. Again, people use these for more complex assets. Just keep in mind that the charitable trusts, there's a little more costs. There's no cost in setting up a gift annuity. But a charitable trust, they can get a little pricey to set up, and then they have to be maintained over time. Different K-1 filings and different maintenance done on the trust itself. But again, if we're talking about a larger asset, a more complex asset, it certainly will fit the situation. It could be quite beneficial to an individual or individuals. And again, similar to the gift annuity, if you would like more information, be happy to talk to you about that. And we could also run gift illustrations to show you, your payouts, tax situation, and things like that for a charitable trust as well. Endowments. Maureen spoke a little bit about these endowments. We have over 150 endowments here at the foundation. Some recent ones, we worked with a person a few years ago, and she had set up an endowment to benefit 3 local Catholic schools using her IRA and required minimum distribution for the qualified charitable distribution to set up the endowments. And then we had a couple recently who set one up during their lifetime, but they've also made provisions through their estate plans, through their will, that the bulk of the gift will come through there to further fund the endowment, again, for education and for helping the poor in Raleigh. Some of the benefits of the endowment is that the funds are managed in line with the USCCB's moral investing guidelines. So those funds are constantly screened to make sure there's no companies there that are involved in massive weaponry or pornography or anything that's against the Catholic faith. So keep that in mind. A lot of other community foundations might not offer that, but we offer that if that's important to you. It's the USCCB guidelines for investing, and that's how our endowments are invested. They're professionally invested by an organization called Marquette, and each quarter you will get an endowment statement showing how your endowment is performing, and then each year you're eligible to make distributions to your designated charities or ministries that are listed in your endowment. Again, and it's permanent. It's in perpetuity. Set up by an individual, it goes into set up in perpetuity, can be funded during lifetime as well as through an estate gift. Again, we've seen a number of them benefit. I worked with a person some years ago who set one up for, she was giving to our seminarian partnership program to help with the education and formation of diocesan seminarians. And then she made provisions through her trust for a stock portfolio to be put into our endowment. And now through that gift, the combined gift there of her lifetime gifts and her estate gift, she's able to fund at least 2 full seminarian scholarships each year. So that was quite beneficial and great foresight on her part. And we're very thankful in the diocese to have a number of priests have gone through the system, have gone through the program, and now they're able to offer the sacraments to the faithful here in the diocese. We're very grateful for that gift. And so there's a lot of neat things you can do with endowments there. Again, happy to talk more about these for your specific situation. Covered all that. And then finally here, before I turn it over to Andy, just keep in mind your documents are a testimony to your faith, right? It's your last chance to evangelize, so to speak, right? And so it is important to have these provisions in there. You can have a faith declaration. You know, Benjamin Franklin started his will in the name of God. I, Benjamin Franklin. Well, we know that God is Father, Son, and Holy Spirit. So we can say in the name of the Father and the Son and the Holy Spirit, amen. I, Ryan Flood, right? So it's important to, again, express our faith through our documents. A forgiveness provision. From the depths of my heart and soul, I forgive anyone I have hurt, consciously or unconsciously, intentionally or unintentionally, throughout the course of my life's journey. And I pray that all will forgive me, right? So we might not have an opportunity to express our forgiveness to someone or ask forgiveness, and we can have that there in the documents. Again, it's important to tithing. We've been given so much here in the United States. We want to be able to, God's calling us to do tithing and help others less fortunate than us. And then Gregorian Masses. Gregorian Masses are 30 Masses, 30 days of Masses said for a soul who has passed away for their eternal repose. There's a whole history of this with a monk going back to 10th, 11th century. You can look it up. But the idea of the Gregorian Mass is very powerful. It's not just one Mass. It's 30 days of consecutive Masses for a soul that's passed away. Now, we don't have the number of priests here in the diocese to have these, but I often recommend the Seraphic Mass Association in Pittsburgh, Pennsylvania. They have a global network of priests that offer these Gregorian Masses. So if this is something that you would like in your estate plans, you can give them a call at the Seraphic Mass Association, and they can get that all set up for you and send you the documents, and you can put that with your estate planning documents, so you have it all there. So that's my part of the presentation. I'm going to hand it over to Andy Blair now. As I mentioned, Andy's a great guy, great attorney. He's right here in Raleigh. He's been on a number of these presentations, and he's going to talk about the various types of legal documents that everyone needs in their plan. Thank you. Take it away, Andy.
Thanks, Ron. Can you guys hear me okay?
Yes, can hear you fine.
I'll make sure. All right, great. Thank you. Okay, so as Ron mentioned, I'm a estate planning attorney here in Raleigh. And do a lot of these, enjoy doing these. I'm a close friend of the Catholic faith. I have two boys that went to Our Lady of Lourdes through middle school, and my oldest is a freshman at Cardinal Gibbons. So glad to be able to get to do these. So Ryan kind of talked about a lot of the options that you guys can do with your planning, and I will talk about the documents to get those done generally, and some of the nuances around those. Generally you want to have a last will at least, and powers of attorney both for finance and healthcare. Some of you may be familiar with trusts. Trusts are another option for planning. And if you kind of have a more complex estate, wider spread of assets, maybe you have some investment real estate and things like that, trust can be a good option too, because one of the most common advantages of those revocable living trusts is that you get to avoid probate, which when you leave things through a will, you don't necessarily get to do that. Okay, next slide. So I'll start with the powers of attorney. So the first one we talk about that's very important is a power of attorney for finance. A power of attorney is to protect you while you are living. So let's say you're in a car accident, you're in the hospital, even as you get older, let's say you develop dementia and you can't manage your affairs. This power of attorney allows gives someone else the legal authority to step in and manage your affairs for you. So they can write checks on your bank accounts, pay off your credit cards. If you need to move into a home or something and sell your house, they can use the power of attorney to sign off and do that. We always recommend, that everyone have powers of attorney for finance and healthcare. The reason being, and a lot of times, for most people, we're lucky enough that we live a long time without needing them. And so, the hope is it kind of collects dust in a drawer, because it means nothing happened to you, that somebody else needed to step in and do that for you. But if you don't have one, it can be a real problem, because the only way anyone can get assistance to help you is through a court-ordered guardianship, which is just kind of a nightmare to go through. And so it's much easier to do so on a power of attorney. There's a couple ways to set those up. I mean, as you can see on the slide, there's general versus limited. A general power of attorney just says, it's just a blanket grant of authority that just says, hey, I give you the authority to do whatever I could do with my own finances. And those are good, because if you think about, it may not be that you have an event where you need your power of attorney for about 10 years, and we have no idea what your assets are going to be, what the situation is going to be. So a general power of attorney is great, because it gives the flexibility that whatever the situation happens to be, that person can generally step in and manage your affairs. A limited power of attorney is just that. It basically says, hey, I'm going to give you some authority, but I'm not going to give you authority over everything. As helpful as these powers of attorney can be, they can also be equally dangerous. Many of you may, have friends or family who, had a situation where sort of a ne'er-do-well son said, hey, I'm going to move in and take care of mom. Let me get her power of attorney. And then a couple years later, next thing you know, mom's penniless, because they used the power of attorney to just transfer everything in their name, spend it on themselves, things like that. So a limited power of attorney can provide some protection for that standpoint, where it says, hey, I need you to help me. I'm going to give you my power of attorney, but I'm only going to give you power of attorney over one account or two accounts, just enough that you can access some of my money to pay my bills and take care of things, but I'm not going to give you control over all of it. You don't need that. And I think there's too much risk there, if I give you that much control. And so you can carve out what you give this person authority for. We do it also, it can be very common in real estate transactions. Let's say you're out of state. Sometimes you will you'll give your real estate agent a limited power of attorney to sign closing documents for you if you can't make the closing, things like that. One other way to set up powers of attorney is what we call an immediate or a springing power of attorney. Immediate means if I sign a power of attorney giving you authority over my affairs, you can take that document to the bank tomorrow. and do what you need to do. Which again is good. And with a lot of married couples, we do that because we say, hey, maybe you need the power of attorney because you're overseas for a work trip for a week or two, and it happens to be when you're selling your house, so you want your wife to sign. You're not incapacitated, so it's not that she needs to do it because there's anything wrong. It's just sometimes more of a matter of convenience, and so immediate powers of attorney can be good. Springing powers of attorney, you usually set up kind of a triggering event down the road that says, hey, I don't need you to manage my affairs. I only want you to be able to step in if I'm incapacitated and I can't do it. So you'll write that in the document and you'll say, hey, this power of attorney is only effective when my incapacity has been certified by, a physician or something of that nature. And then that way, you don't have somebody sneaking around with your power of attorney, trying to go change your accounts and do things while there's nothing wrong with you. And one of the key things about these financial powers of attorney is sometimes you can draft really good documents, but if you appoint someone as your power of attorney who's not trustworthy, it can still be a nightmare. So what I think is most important there is a lot of times more who you pick to be your power of attorney, than necessarily how you draft the document. They're both very important, of course. Next slide, please. Okay. So the other power of attorney is the healthcare power of attorney, or sometimes called an advanced medical directive. And those are kind of broken down to situations. When we usually talk about a healthcare power of attorney or a healthcare agent, that's somebody that says, hey, you're in a car accident and you were in a temporary coma for 3 weeks or something to that effect. Your healthcare agent under this document is the one that comes in. They talk to the doctors. The doctors say, hey, we think they should have this surgery. We think they should have this medicine. Let's try giving them this treatment. And because you're incapacitated, your healthcare agent gets to make those decisions and tell the doctor what to do, as long as you can't do them yourself. The advanced medical directive sometimes is called a living will. That is more when you're in a terminal condition. And so, you're in the hospital and the doctors are like, look, she's incapacitated and, things are so bad, we're going to call hospice in. Maybe there's a week left. What do you want us to do? Do you want us to keep treating them, or do you want us to just let them go? And so, everybody throws around the term pull the plug. This kind of advanced medical directive living will covers those pull the plug situations. And, normally the way we draft those is you can make the decision now. So you can sign an advance directive that says, if I'm terminal and incapacitated, I want you to stop all treatment. So even if your husband or wife or kids are your power of attorney for healthcare, if you select that option, the doctors will follow your wishes, and they're not going to, they won't care what the family says. If they say, no, keep her on a ventilator for 6 months, we want to see what happens. If you sign it that way, you can do it. You can also leave that discretion to your family to make that decision of, hey, let's try something new. Let's keep them going for a little while, see if they'll come out, things like that. There is also some guidance in that Catholic binder that Maureen and Ryan were talking about earlier. One of the things that you can do in that document, some of it relates to healthcare decisions, so you can write in custom instructions, religious objectives, things like that. You can also put that in the healthcare power of attorney and provide very specific custom instructions on what you want for end of life care. And if there's other treatments you don't want your healthcare agent to do, for religious reasons, medical reasons, other things, you can enter those in the healthcare power of attorney and advance directive as well. Okay, next slide. Okay, so that covers it for the powers of attorney. So the next thing we'll go over is your will. And sometimes people say, well, I'm married. I don't need a will. I'm married. My spouse is going to get everything. And that's only true if you leave it in your will. If you pass away without a will, we call that being intestate or intestacy. And when you do that, you're kind of leaving your future up to the North Carolina statutes, and they don't always do what you think they're going to do. For one, if you are married and you have kids and you die without a will, the law does not give everything automatically to your spouse. The law is going to say, okay, your spouse is going to get, it's dependent on how many kids you have, but your spouse is going to get a third or half, and then the other half is going to be split amongst your kids. If your kids are older and grown, maybe that's not a big deal. But if you have young kids who are minors, what it means is now you have to go get court-ordered guardianships for all the money that your kids are going to inherit, because as minors, they can't take it. Other times maybe your kids are 19 in college, and that's not when you want them to have, significant money in their pocket to, to go blow in their teenage years. And so a will can help you set up terms to say, if you've got young kids, leave it in a trust for them, until they turn 25 or 30 or something to that effect, so that the money can be spent on them while it's in that trust, but you're not putting it in their pocket to go do what they want to do with it. Also, if you have minor kids, wills are very important for naming a guardian. So if something happens to you while you still have young children, you absolutely want to have a will to name your guardian, because otherwise it's kind of a race to the courthouse and which family member, wants to go apply for custody and can get it. And you just don't want to create a situation where there's a fight, after you pass away as to who's going to get the kids. Can you write one yourself? You can. North Carolina will recognize wills that you do yourself, but only if they're handwritten. If you type it, you have to have two witnesses sign it. And we see a lot of problems with handwritten wills because, there's just some legal language you want to have in there about who gets appointed, how you appoint guardians, how you appoint executors. If you've got young kids and you do need trust terms, those are very difficult to write yourself. So while you can, it's usually not recommended. I can tell you, and if anybody's ever had to deal with an estate, a lot of people don't like paying lawyers, and they'll say, well, I'm not going to go pay that lawyer $1,500 for an estate plan. That's way too much money. It'll cost you 10 times that amount if you die without one and all your family members start suing each other because you don't have any plans. All those cliches about, ounce of prevention, pound of cure, all that good stuff is really true in this context. And it's way more expensive to fix on the back end than to do it right on the front end. And the other thing, this goes back to a lot about what Ryan talked about. The North Carolina intestacy statute only covers family members. So if you want to make gifts to the church, if you want to make gifts to the foundation, those will not automatically happen without a will. And so in order to do that, you want to have a will so you can, leave your family what you want to leave them. But with regard to the church and the foundation, that's only going to occur if you set it up in the will, or at a minimum, if you want to leave portions of an IRA, things like that, you can set the church or the foundation up directly in the IRA. But those are a lot of discussions we have during planning where we'll say, okay, you want to give the church money. What's the best way to do that? Is it good to leave them an IRA? Do we want to write a gift in the will, have it funded with other assets? It's been very common, especially in the Catholic Church. People will leave their houses to the church. And a lot of times that, they will let nuns and priests reside there. I know there's a couple houses in Raleigh that are like that. I think when my kids were at Lourdes, a few of the sisters there shared a house that had been left to the church. And again, all of that's got to be written in the will for it to happen. And then your will also appoints your executor, and that's the person who kind of steps in after you pass away, and they're the one that has to handle settling these things. It does come down to distributing assets, but there are other things that men I think about, like you got to cut the cable off, you got to cut the phone off, you got to close the credit cards, transfer the car titles, all of these things. And so you want to be in control of who your executor is, and if you die without a will, anybody in your family can come in and say, hey, I want to be executor. The state allows for an executor to get a commission. And so, some people say, ooh, I'm going to sign up to be the executor so I can get paid my commission, not because they want to follow your wishes and do what's right by everybody. And so you get to control who that person is. And that's why it's important having a will. Okay, next slide. Okay, so revocable living trust, which I touched on a little bit earlier, these are good for avoiding probate. Um, and probate is the process where when someone dies, another person has to have legal authority. So if one of my parents passed away, I couldn't just walk in the bank and say, hey, I'm their son, you need to give me all their assets. The court has to appoint someone and give them legal authority over that, and that's your executor. Now, the big problem with probate is that everything has to run through the court and it has to get court approval, and it's very slow. For example, in Wake County now, if we file documents to open an estate, we usually don't get an executor appointed for anywhere from 3 to 6 weeks. And so in that interim, you're just sitting there having to wait for the court. It could tie you up. You don't have access to cash if you need to pay bills, funerals, things like that. So what the trust does is any asset that you put in a trust before you pass away is not subject to probate. And it's good for things like investment accounts that aren't in IRAs or 401ks. It's good for real estate. And other things like that. And what happens is a trustee manages a trust. And when you pass away, normally you're the trustee of your own trust, but when you pass away, the new trustee gets to step in immediately. They don't have to wait for court appointment, and they can get access to the accounts right there, so they can pay your funeral bills, they can settle your credit cards, do all of those things without having to wait for delays on the court side. Whether you need a trust really depends on the type of assets you have. Some things, for example, you couldn't move your 401k into a living trust because the only way you could get that money in there is to liquidate it. You don't want to do that because then you have to pay all the income tax on it. And so you also want to have the right type of assets to put in there. So if all of your net worth, and even real estate doesn't go through probate for the most part, but so if most of your net worth is tied up in a house and qualified retirement plans like 401ks and IRAs, a trust may not make a difference unless there are some other reasons to do it. For example, like what Ryan talked about with setting up sort of charitable gifts or things like that for the church or the foundation. If you want to do that, a revocable trust is a good idea to have. And what you can do is leave assets to the trust to fund that if you decide that leaving them IRAs and things like that directly is not the best way to do it. There are a lot of charitable and ways for tax savings that you can use a trust for. In some other situations that it helps, I had one estate one time where a lady died with no kids, but she had 31 nieces and nephews. And a trust was good for that situation because if you go through probate, all of those 31 nieces and nephews have to agree on their distribution. They have to sign documents that get turned into the court and approved. And so even though she didn't have a big estate, having an administration with that many beneficiaries would have been an absolute nightmare. So moving that into a trust meant we didn't have to get court approval to do it, and it made the administration easier. So there can be a lot of reasons for doing that. Okay, next slide. And some of this we talked about. These are some good examples for the healthcare power of attorney. And one comment about wills and trusts. While there are some things that we say, hey, you should have these things in your will and trust, the good news about them is that you can also put in anything you want. So we have, I'll draft statements of faith for people, like Ryan talked about, where they want to have that in the will and trust. You can lay out how you want your service to go, who you want to preside over it, what music you want to play. As she's talked about here in this slide, forbidding physician-assisted suicide, protecting the life of unborn children, all of these things, unethical medical treatment, all these things you can draft language for in your documents, because this is sort of an embodiment of you and what you believe in. And so, after you pass away, or if you're incapacitated and people are helping you, you want them to know what you believe in and how you want things to be done. And so the good news about these documents is that we can draft all of this stuff in, so everyone knows what your wishes are. Next slide. And again, same thing here. We touched on that a little bit, that you can talk about whether you want to be cremated or buried. Anything related to the disposition of your remains can also go in primarily wills and healthcare powers of attorney. One last thing on asset titling. Sometimes you say, hey, I've got this will, but wouldn't it be a lot easier if I just have joint accounts with people? And that helps too, especially in a marital situation. A lot of husbands and wives have joint accounts, and that's great because, you both have access to the account. And then when one of you passes away, um, it automatically goes to the surviving joint owner and does not go through probate. So when we talk about avoiding probate, while revocable trusts are good, sometimes if you don't need a trust, there are other things you can do to help on the probate side. And one of those is having either joint accounts, or another one's called POD or TOD, and that means transfer on death or payable on death. And the difference between a joint account and that is just that whoever you leave that account to doesn't have current access. They just get paid at death. That account automatically transfers to them. Next slide. And so one of the things, going to an overview of what you need to think of when you go through this planning process is, it's important to know where your accounts are titled. So for example, a will does not control a joint titled account, but it's fine to have a will and a separate joint titled account. Just make sure, we want to coordinate all those things. In thinking about the next one talks about beneficiary information. Wills don't control IRAs, life insurance, or 401k. So you always want to make sure that your beneficiary beneficiary designation forms are updated. So for example, if you're going to leave a gift to the church through your IRA, we don't need to write that in the will as long as your beneficiary designation is correct. And so as part of the process of drafting wills and doing planning, we'll want to look at those beneficiary designation forms to make sure they're okay. And one of the last things that can be kind of tough is, a lot of people, they say, well, my stuff is private. I don't want to talk to my kids, or I don't want to tell them. They don't need to know what I have going on. And that is somewhat of a personal decision. However, the more you're willing to tell them, it will help them when the time comes that they know exactly what they need to do and what to expect. And there are ways to do that without saying, hey, here are all my documents, here are all my assets, here's how much I have. Sometimes you can, have those discussions without necessarily giving that all away. Next slide. Okay, I think that's it. Thank you all. And
Thank you, Andy. Yes, yeah. Right, great. I'm here, Andy. Thank you so much again. As always, we very much appreciate your volunteer time today as you share this wonderful overview with us. So I wanted to take the opportunity to just share a little bit more about the foundation funds and recognition events. So again, as I shared at the beginning, we are the Plan Giving and Endowment House of the Diocese. And so as such, we manage the Father Thomas Price Society. And this is just a membership group for people who have left a bequest to a parish or the diocese or the foundation in their estate plan, or have created an endowment while they're alive. And this is just a way for Bishop Zarama to say thank you. We have an annual mass and breakfast this year as opposed to luncheon. And again, it's when Bishop Zarama gets to say thank you. We do not need a copy of your will. We do not need to know what you've left or how you've left it. But if you know that you have left a designation to your parish or ministry, please, I encourage you to go on our website and join the Father Thomas Price Society. And again, our annual breakfast is Tuesday, October 24th. So we'd love for you to join us. And again, you can email us here, Alicia at the foundation, and we can get you signed up. Next slide. The Home Mission Fund. So this is another fund that at the foundation we raise money for, both annually and through estate planning. Up until 2006, the Diocese of Raleigh was considered a rural diocese, and we received funding from outside organizations such as Catholic Extension for us to build churches in rural areas. And once we got too big, we don't get that funding anymore. And so this is for established parishes that are in rural areas that need to expand the building. And so we give grants of up to $500,000 to the parish for them to start their capital campaign and get initial seed money. And again, it's not for mission churches, it's for churches that are already established here, but they're in very rural areas and they don't have the means to build the larger worship space that they require. Next slide. The Seminary and Partnership Program, while in fact the BAA funds the vocations office and some expenses of seminarians, we raise money annually for the Seminary and Partnership Program. This is a donor designated fund, meaning your money only goes to seminarian education. So if you feel passionate about seminarians and their education, we'd encourage you to look on our website, maybe make a gift this year, or consider putting it in your estate plans. We currently have 15 seminarians, and it costs about $50,000 a year to educate them. So if this is something you're passionate about or feel strongly about, we'd love for you to consider the Seminary and Partnership Program as a beneficiary today or in the future. Next slide. So on here, you can send, Alicia has questions that she is going to read at this point. We've captured them ahead of time. If you have other questions, we can put them in the chat. I'd like to leave you, before Alicia goes to the questions, with two things. Number one, I'd really like to ask you to discern a gift or some portion of your estate as a legacy to the foundation through in a parish or whatnot. I know people say, I don't know how much to give. I don't know what my financial situation is going to be at the time of my passing. But so we like to encourage people to think about a percentage. Maybe it's 2% of your estate or 5% of your IRA. But if you think about it in a percentage, it means that 95% stays with your family or your heirs, and then 5% goes to a charity. So we'd like you to consider that. And then finally, our website. I know most of you went on our website to sign up for the seminar today. There's a tremendous amount of information on our website about our endowments, about who we are, what we do, the funds that I just spoke of. So it's a great resource. And then if you have very specific questions or want to meet with someone, certainly Ryan is our plan giving specialist. He's available for phone meetings, just a quick phone call to answer a quick question and or a face-to-face meeting. And again, Andy's contact information is at Pointer Spruill, and we'll send that out as well when we conclude this. So if you need to engage an attorney or want someone to take a look at your will or draft something, Andy would be very much able to do that for you. So I want to thank you for your time, and I'm going to pass you on to Alicia, who's going to moderate some of the questions. Thanks, Alicia.
I just have one quick comment to make, Maureen and Alicia.
Sure.
We have this seminar is going to be on the road in October and November. So if you're at Immaculate Conception right in Durham or Immaculate Conception in Wilmington, we'll be there live. So, and some of the other parishes, just, this is a lot of information. If you'd like to see this seminar in person, we're going to be definitely at those parishes and maybe more. So keep a lookout in your bulletin.
Thank you, Ryan.